Greetings and welcome. My name is Edward R. Kinglet, and I am the managing attorney at Oakcrest Law Group. I will be reviewing estate planning basics. In 1978, Benjamin Franklin famously quoted these famous words: "There is nothing more certain than death and taxes." Now it is now 2023, over 200 years, and nothing could be more certain than talking about taxes and death, and basically the fact that this is truly a taboo topic. No one likes to think about dying, and I think that is why majority of people do not set up an estate plan. I'll show you through some slides later percentages, interesting percentages of the people who plan versus the people who don't plan. And really, this seminar is meant for you to be encouraged, to be enlightened with respect to why you should definitely plan. Close your eyes and figure out, who are the people that will be missing you, but also who are the people that are dependent on you. And the last thing that you would want is to be a burden on your family. And so obviously, when people tell me, what do I care? I'll have died already. And that's really not what I'm referencing. It's really about the people who you leave behind that you actually love, and the fact that you do not want to be a burden to them. So really, it is a way to organize things, to catalog things, to make decisions on the individuals, the people, the assets, the things for you to make these critical decisions, because there's no one better than you, the owner of these assets, to make these types of decisions. And that goes with, living with a peace of mind that you've done everything possible, that you could go to sleep with a peace of mind every night, that you have literally dotted the I's and crossed the T's with respect to setting up an estate plan, so that you know that everything will be taken care of. Now, one of my most popular questions is, who needs an estate plan? And if you look at my list of bullets here, it's almost everyone. It includes a wide range of individuals. Probably the most popular reason for people to consider an estate plan is because they are protecting assets, or they have specialized or sophisticated assets. But it's not necessarily for those individuals who have substantial assets. It could be simply you want to protect someone who's a minor, for example. And so the first bullet is anyone that has children or grandchildren that they're responsible for. You could be the guardian of your grandchildren, or you have children that are younger than 18. You will need an estate plan that has provisions with respect to who will be taking care of them if you are not going home. Real property is another category. Real property is a substantial investment, and you will need an estate plan to properly protect it in the event that you get sick and or pass away. The other category in California is personal property, anything other than real property, if it is valued more than $180,000. That's the triggering event with respect to a trust. Now, you could have a will if your assets are south of that. That still is considered having an estate plan. But particularly with respect to planning for trusts, it's real property or personal property of $180,000 or more. The other category is anyone who wants their assets to be transferred to a specific loved one. And here in California, if you don't have an estate plan, the state has already passed rules of who will be inheriting. For example, when James Dean passed away, he was not married, no children. His mother had predeceased him. And of course, he was only 24 years old. He didn't have an estate plan. The state of California decided to give it to his father. Now, for many of you, that could be the appropriate decision, but if you don't know, James Dean's father had abandoned the family when James Dean was very young. And so if you wanted only to go to one child versus all three children, or perhaps if you wanted to go to charity or to a friend, or anyone else, that is a reason why you would specifically have to set up an estate plan with those specific instructions. And then finally, the other category that is very popular these days is a blended family. I will be sharing a very instructive video about how it could be complicated. Things could get complicated rather quickly with a blended family with respect to one spouse passing away. You want to make sure that the child who is left behind from the parent who passed away has protections. Now, I wanted to look at the numbers just to give you some food for thought and hopefully additional motivation for you to consider planning. It is estimated that about 70% of the public does not have an adequate estate plan. It used to be 80, but I think the pandemic has shook the nation. And it looks like it got 10% lower, so 70%. Still a majority of people. And so anytime I do public speaking, anytime I speak to individuals, these numbers are always validated. Although 40% have a will and 17% have a trust, most people don't have all of the pieces in proper place and alignment to constitute an adequate estate plan. So for those 20% of so that have a trust, I call it the Michael Jackson phenomenon. They have a trust, they think they're protected, but in fact, they're not. In the case of Michael Jackson, when he passed away, nothing was physically transferred into his trust. His house wasn't into his trust, his business, his music catalog, his assets, such that when he passed away, he still had to go to court. And so there's a lot of critical things that you need to do when you set up an estate plan. It's just not simply assembling pages together, stapling them, witnessing them, and signing them. You have to do things in a very particular way in order for them to be effective. And then finally, most cases will have to go to probate, which can be 2 years or more in California before the family can receive closure. And so, people say, well, what's the big deal? It'll be administered. But when you have states, when you have counties that are busier than others, sometimes it's more than just 1 year. It can take up to 5 years in my experience. So planning for incapacity, I want to talk a little bit about the phases that we go through in life. And a lot of people tend to oversimplify living and then all of a sudden dying. In fact, statistically, you could be incapacitated up to 7 years, meaning you could be alive, your heart could be pumping quite well, but in fact, you have no mental capacity. So you could succumb to certain cognitive disorders like dementia, for example. So any good plan should have provisions to protect you while you are mentally incapacitated. It can strike at any time. It's not for people who are past 86 years old. I've seen in my practice people who are incapacitated mentally at a younger age. It can be triggered by viruses. It could even be triggered simply by being dehydrated, for example. Failing to plan means a court will appoint a guardian. We have a very famous case here in California in Britney Spears. It's called a conservatorship. So conservatorships can happen to people who have mental disease and or mental incapacity. And so any good estate plan has provisions that will include the protections in place so that if you do succumb to dementia, for example, you've already decided who are the people who will be making decisions and taking care of you. So the next thing I'm going to go over is what exactly happens if you die without an estate plan. And as you're aware, one of the main things that we're trying to do is avoid the courthouse, or what we call probate. So how it works is some property passes automatically to a joint owner or to a designated beneficiary, which is what I call beneficiary designated assets. So a lot of accounts like retirement plans and life insurance, when you set them up at inception, there will be a section for you to fill out who exactly is the beneficiary. And so this is the part where you say my spouse, my brother, my mom. You will put in the percentages, and so long as they survive you, they will be able to inherit these assets automatically without going to probate. One important thing to keep in mind is that if they've predeceased you, then we have a problem. Or, for example, if you list a minor as the beneficiary of a life insurance policy, an insurance company will not give a check to a minor, which will then trigger probate. So these are some of the many ways to generally transfer assets, but they're not perfect ways. They still are subject to probate somehow, some way. So other than that, all other property generally pass according to state intestacy laws. So basically, if you don't have an estate plan, just like in the James Dean case that I referenced earlier, the state has already figured out who your assets shall go to. And so when people like Prince passes away without an estate plan, when people like James Dean pass away with no instruction, the state says, well, since they didn't make the important decision, we've already passed laws that will already determine who shall inherit, and that's what we call intestacy laws. Intestacy means you haven't made the decision, and so the state will. Now, avoiding probate, here are some bullets on how to avoid probate. So you can own property jointly with rights of survivorship. So it sounds exactly as it's written, rights of survivorship. So two people, husband and wife, two spouses, they own property as joint tenants with right of survivorship. If one passes, the way it is titled means the survivor takes all. The survivor takes all. That doesn't mean that if both of them pass away, it'll avoid probate. So basically, it just avoids probate at the passing of the first owner, Obviously, complete beneficiary designation forms for properties such as retirement accounts and life insurance, all of that. And also update them. So just because you filled them out in 1974 or 1983 or 1992 doesn't mean that the people that you have listed are the correct ones in 2023 and beyond. Where this comes into play is we have to go to probate for old assets, where, for example, prior to marriage, the person who passed away listed their mother who has predeceased them, and they never updated it to list the new spouse or to list the children. So you generally have to keep these up to date. You can also make lifetime gifts, basically giving away your assets while you're alive so that they don't need to be transferred after death. And then the gold standard is using trusts because it is a very efficient, a very methodical way to avoid probate. Now, wills and probate and how it works. So basically a will needs to be probated in a court. So the way the court is organized in California is through counties, and in every county there is a probate court that will administer that will. It's filed with it. The executor or the personal representative will be in charge of collecting or marshaling, organizing, paying off debts, mortgages, things like that, taxes, and then ultimately distributing property to the heirs according to the provisions in the will. Now, like I said earlier, a majority of people end up in the court, anywhere from 70 to 80%, for whatever reason will end up in probate court. It generally lasts for about a year in California, but we have some busier counties, and I'll go over a video that does a deep dive into these specifics. Okay, now here's an example of how probate works. It costs approximately 5 to 10% of the fair market value of the asset. So that means if you own a home for $1 million that is subject to a $600,000 mortgage, the court will assess a minimum of 5% on that $1 million. The second thing that you need to know about probate is it takes a long time. It takes about 1 to 2 years across California, with some exceptions for the larger counties like Los Angeles, where it can easily take 3 to 5 years. Now, how does a trust work? It's essentially a versatile estate planning tool. You can amend it, you can revoke it, you can update it. It protects against incapacity, so it has provisions to cover you during the period where you're still alive but mentally incapacitated. Again, a very important aspect of estate planning is not just covering you if you've passed away, but also covering you during the period where you have no mental capacity. And obviously it avoids probate, and it also has a way to minimize taxes One example of minimized in taxes is the step up in basis after death. Allows the adjustment of the basis for the calculation of capital gains. We find a lot of people who avoid setting up an estate plan are gifting real property, for example, while they're alive, which is carryover basis and not step up in basis. Allow professional management of assets. So people who have minors can choose a professional like a fiduciary to manage the trust while their children are minors. Or perhaps it's a good idea to elect a professional for siblings who are not getting along and not choosing one over the other, for example. Provide safeguards for minor children, elderly parents, and other beneficiaries. So a trust is an agreement between three parties: an owner, a manager, and a beneficiary. And when you set up your trust, you're actually all three of these individuals. You're the owner because you own the home. You're also the manager because you get to decide when to refinance or when to rent or when to sell. And you're also the beneficiary because if you sell the house, you can benefit from the proceeds of the sale. Now, in your estate plan, while you are the trustee, if you subsequently become sick, you've already determined, for example, that your adult son will serve as the manager. Because you're still alive, you still continue to be the beneficiary nonetheless. However, once you pass away, you've already decided through your estate plan who's in charge and who will inherit from your estate. When this happens, everything is in place, and those individuals will come forward to manage your estate plan. Having a blended family where each spouse was previously married or was in a relationship that produced at least one child introduces interesting factors to consider. I represent clients who have been married their third time, and in each marriage they produce at least one child. In the Brady bunch, Mr. Brady had 3 sons from a separate marriage, and Mrs. Brady had 3 daughters from a separate marriage. If one spouse passes away, and the surviving spouse inherits all of the assets, this introduces a level of complexity for each spouse to consider if one of them were to pass away. So in a worst case scenario, if Mr. Brady were to pass before Mrs. Brady, and we assume Mrs. Brady inherited the entire estate, she could intentionally or unintentionally disinherit Mr. Brady's 3 sons, and they could get nothing. So exploring your options, costs versus peace of mind. So this slide goes over the different ways, different planning methods and options in engaging in estate planning. So obviously the first one is free. That is no plan, and that's arguably about 40% of the 70% or so that end up in court. So this is the one where you'd end up paying probate fees, and it's just not a good deal. Now, if you don't want to use an attorney, there are self-help legal forms driven methods, and those range from $250 to $1,000. An example is LegalZoom. I personally like LegalZoom because they do all of my marketing. The reasonable consumer will realize that this is more difficult than LegalZoom is explaining it, as it's not just simply filling out blank forms and documents. You actually do need advice on how to do things, so to speak. Now, the next 2 options deal with an actual attorney. The first one is an attorney with multi-services, or what I call a general practicing attorney. They do all sorts of things. They do family law, they do plaintiff's law, they do immigration, and then they'll squeeze in estate planning. They have additional business lines. I'm aware of certain attorneys who are also realtors, who also sell insurance, and it's sort of a loss leader operation. They will get you in, but then they'll also want to refinance your house or even sell your house because they know that they'll make 3, 5, or 6% on the sale price, for example. Those fees are $500 to $1,500. for example. And then there's a firm like ours. This is the only thing that we do. We only do trusts, estate planning, and probate. Our focus is here. We do trust administration. So one good way to separate a general practitioner from the rest is, what happens if you pass away? Do they have experience in actually administering the trust? And so that's usually reserved for people that know exactly what they're doing. So we do full trust administration, which really means when you work with us, we also can tell you with a straight face that if they pass away, we can assist in the administration, meaning we can carry out their wishes with what's written in the trust. And then we also do probate, and that's for people who have not done any planning, or else they have an estate plan and the estate plan doesn't have the appropriate provisions. Now, those fees are normally $5,000 and up. So our basic estate plan package comes with all of this. We have the living trust, which was the focus of this presentation. There is also a certificate of trust, which is a document to give to third parties. Usually you'll give this to a mortgage company, you'll give this to a bank, you'll give this to a financial institution. It's a wonderful way to give the four corners of the trust the essential information without giving away too much information. For example, they don't need to know about your other assets. They don't need to know about who actually is the beneficiary. They might need to know who the successor trustee or manager is. And so, for example, your trust could be 100 pages long. The certificate of trust is only 1 to 3 pages. It also comes with a pour-over will. A pour-over will is not just any will. It's a special will that goes in collaboration with a living trust. And so recall the Michael Jackson situation where he had a trust, but nothing was funded in the trust. If that is the case, you pass away with a trust that is empty, meaning they have not been transferred to the trust, we will use a pour-over will as a catch-all provision. It is a will, so that's the bad news. We must go to court. That's another bit of bad news. But what it does is it will ultimately transfer the asset into a trust. So what we've seen happen is an individual has 3 properties, 2 of the properties on the trust, so those 2 properties avoid probate. That third property, for whatever reason, was never transferred to the trust. We will use this pour-over will to pour over or transfer that third property into the trust. Advanced Healthcare Directive. This document has several things in it, including a healthcare power of attorney, which is the most important document. The healthcare power of attorney is a document that allows a third party to make healthcare decisions for you. It also includes provisions about the end of life, heroic or artificial measures, for example, and also final disposition of your remains. HIPAA waiver is a medical confidentiality document that says these people can view my otherwise private medical information. Durable power of attorney is a supporting document to your living trust. It allows a third party to sign your name to transact financial transactions. And it also comes with a grant deed for those of you that have real property. It's one real property. We will review and assess the vesting of your current real property, and we'll prepare the necessary documents for that one real property to be transferred to your trust and record it with the county recorder and assessor's office where the property is located. If you have minor children, we'll prepare nomination of guardians so that it's not a guess of who shall be taking care of your minor children if you pass away. We'll also nominate a conservator for you in the event in the future if you need a conservator or a decision maker for your health care. That is in alignment with your Advanced Healthcare Directive. The people making healthcare decisions are also going to be your conservators. Personal property memorandum. So if you have something of value, it could be an heirloom, it could be a painting, it could be a Fabergé egg or a Tiffany lamp. These documents will allow you not only to transfer it to your trust, but to designate who shall get it. If you have 3 kids, a painting cannot easily go to 3 people. You can't just cut the painting in thirds. You can say my middle child, my youngest child, or my oldest child gets this personal property. Also, letter of wishes. It is a firm favorite. It's something that I think sets us apart from a lot of other law firms. This is a non-legal document, and it's basically your final I love you letter to your family, to your loved ones. And it basically explains why you did this, why you're giving to charity, why you're giving your child 1% more. I just had a client who had 3 kids, and they clearly had a favorite. So the 3 kids, the 2 younger ones were getting 33% apiece, and the older one was getting 34%. So, for example, if you were going to give a child a little bit more, you can explain in this letter. This letter could be simple. It could say, I tried my best, I love you. Or it can be very specific. We have clients that will put the song that they would like played during their memorial, for example. Funding instructions is a document that goes over step by step of exactly what you need to do to properly fund your trust. Recall that Michael Jackson didn't fund his trust. We put a premium on the funding of your trust. So not only do you get our instructions, but you also get our guidance. And we feel that that is one of the most important things that we can do to assist you when you hire us to assist in your estate planning. And then finally, assignment of the personal property. Again, it goes hand in hand with the memorandum. This is a blanket assignment document that says all my personal property is hereby transferred to my trust. So the basic estate plan package, all of that I just went over is a special pricing of $3,850. And we also have financing available through Affirm. If you'd like any information, please let us know. Now the process takes about 6 to 8 weeks. It's a very specific, methodical process. We make sure that you understand everything. If you need to review any specific provision, we make sure you have that opportunity before you actually sign. And the reason why it would be 7 versus 6 or 8 versus 6 is because you're not ready. And we just want to make sure that you know exactly what you're signing. So here is a QR code. Please scan it. Through this code, it takes us through our scheduling portal where you can book a complimentary introductory call to go over the process. It's simple, it's easy, it's online, and it can be done through the privacy of your own home or office. And if you have questions, you can also scan this code. You can schedule a consultation where you can ask some of your preliminary questions, or if you're ready, you can also schedule that appointment. Email is trusts with an S at oakcrestlaw.com, or you can call us at our 1-800 number, 800-631-1881, 800-631-1881. Thank you for the opportunity to guide you in this process, this very important process called estate planning. Take care and be well.